A truly remarkable event just unfolded in a Manhattan courtroom, one that strikes at the very foundation of Donald Trump's decades-long narrative of business success. Inside that courtroom, the man who knew where every single dollar was buried, the man who managed every ledger and understood every intricacy of the Trump organization, stood before a judge and made a startling confession. Allen Weisselberg, Trump's longtime chief financial officer, admitted that he lied under oath. He didn't just make a mistake, he confessed to committing a felony by deliberately misleading the court to protect Donald Trump. This isn't a political talking point or a media allegation. This is a sworn confession from the man who ran Trump's money. And it raises the single most dangerous question for the former president. If his CFO is going to prison for lying to protect him, what does that say about Trump's own testimony? Let's examine exactly what transpired and why this moment is a pivotal turning point in understanding Trump's legal vulnerability. In March 2024, Allen Weisselberg, a figure synonymous with the Trump organization's financial machinery for decades, appeared in a New York courtroom and pleaded guilty to 2 counts of perjury. He admitted to providing false statements while under oath regarding the inflated valuations of Trump's properties. Specifically, he confessed to lying on the witness stand during Trump's civil fraud trial about the financial documents used to secure loans and insurance policies. This is a profound development. We are witnessing Trump's top financial professional acknowledging that he engaged in criminal dishonesty within a judicial proceeding to portray his boss as wealthier than the reality reflected. Weisselberg agreed to a sentence of 5 months in prison for this crime of perjury. It is crucial to pause and consider the gravity of this. A 76-year-old man agreed to go to jail because he lied about someone else's money. Weisselberg did not undertake this risk for his own personal gain. He didn't lie to pad his own pockets. He lied to defend the narrative of Trump's immense wealth. He lied to inflate Trump's assets and financial liquidity. He lied because, apparently, that is what was required when you operated within Trump's inner orbit. The institutional culture surrounding the former president relied so heavily on maintaining this illusion of prosperity that his own CFO committed a felony to keep the storyline intact. Now, we must turn our attention to Donald Trump himself, because this is where the situation transforms from a story about a subordinate into a potential crisis for the principal. Legal experts have spent years analyzing Trump's recorded statements, his past depositions, his courtroom declarations, and his sworn affidavits. Consistently, they identify the same troubling pattern. Trump articulates positions while under oath that diverge sharply from written evidence. He makes assertions regarding his assets, his business transactions, and his knowledge of key events that are directly contradicted by the documentary record. Judicial officers have openly challenged his credibility. Investigative journalists have cataloged the inconsistencies. But now, the landscape has shifted. His own CFO has admitted that providing false information while under oath regarding Trump's financial position was effectively part of the job description. Trump's legal vulnerability regarding perjury is consequential because, unlike some of the more complex legal theories surrounding him, such as RICO charges or election interference, perjury is easy for the average person to understand. Perjury simply means you told a lie while under oath. That is it. You raised your hand, you swore to tell the truth, and then you didn't. If government prosecutors can demonstrate that Trump deliberately submitted misleading declarations throughout any of these legal proceedings, he may confront criminal charges carrying actual prison time. We are not talking about monetary penalties or settlement agreements. We are talking about incarceration. And with Weisselberg now admitting to perjury for lies he told to protect Trump, the precedent is established. The door has been opened. This narrative strikes at the heart of Trump's most valuable commercial asset, his reputation as a billionaire businessman. To genuinely comprehend what is happening, we must investigate the Weisselberg circumstances in detail, because they reveal everything about the Trump organization's structure and its legal exposure. Allen Weisselberg was not some low-level accountant or an incidental employee who got caught up in a lie. He was the chief financial officer for the Trump Organization for decades. If anyone on earth understood the factual details concerning Trump's wealth and his corporate activities, it was Allen Weisselberg. This individual just acknowledged that he lied when sworn to protect Trump. Let's traverse what Weisselberg genuinely pleaded guilty to, because the details are damaging. He acknowledged 2 counts of perjury connected to Trump's New York civil fraud proceedings. Specifically, he admitted to lying under oath about Trump's inflated property valuations. These were the financial documents that Trump used to present himself as more economically substantial than his genuine circumstances reflected, primarily to obtain better terms from banks and insurance companies. Weisselberg also admitted that he lied about these documents on the witness stand during the trial itself. This wasn't an old lie from years ago. This was Weisselberg standing up in a current legal proceeding and lying to a judge about the financial evidence at the core of the case. The plea deal required Weisselberg to serve 5 months at Rikers Island. That is real institutional confinement. And we must remember, this represents the second time Weisselberg has faced judicial consequences for his work at the Trump Organization. He had previously pleaded guilty to tax fraud charges and served time for that as well. Consequently, Trump's longtime financial gatekeeper has now taken the fall twice, both times for activities directly connected to his role in Trump's business. At a certain stage, one must question what kind of organizational culture produces executives who repeatedly commit felonies in the course of their daily duties. The perjury that Weisselberg confessed to related directly to efforts magnifying Trump's business image and financial liquidity. Let me explain what that means in practical terms. Trump's financial identity is built upon the assertion that he possesses remarkable wealth, a billionaire many times over, positioned among the wealthiest individuals in the country. That perception of prosperity isn't just about ego. It forms the foundation of his entire business model. When Trump interfaces with banks for loans or insurance companies for policies, his perceived wealth influences the terms he receives. Wealthier individuals get better interest rates. Properties with higher valuations get better coverage terms. Consequently, a substantial economic incentive exists to depict oneself as financially abundant on paper. What judicial authorities demonstrated within the civil fraud case, and what Weisselberg's perjury plea validates, is that Trump's enterprise methodically exaggerated his property valuations throughout financial documents. They claimed properties had greater square footage than they actually did. They claimed values that defied market reality. And when they came under scrutiny in judicial chambers, Weisselberg lied under oath to defend these fabrications. He committed a crime, perjury specifically, to maintain the narrative that Trump held the financial position he claimed. That is not an opinion. That is what he acknowledged in a court of law. Now, let's discuss Trump's personal statements, because this is where the narrative becomes substantially more consequential. Legal professionals and reporters have thoroughly investigated Trump's recorded declarations accumulated over many years, and the pattern they found is striking. Repeatedly, Trump makes statements under oath that appear to be incorrect or deceptive when contrasted with emails, financial statements, and other proof. He overstates his financial position. He understates his involvement in questionable transactions. He contradicts statements he made in previous depositions. This does not represent a singular instance or an occasional mistake. It represents a pattern showing itself consistently across numerous legal battles. Judicial authorities have observed this pattern, and they haven't remained silent. Throughout various proceedings over the years, judges have challenged Trump's credibility, identified inconsistencies in his statements, and imposed penalties when they determined he manipulated the truth. The judge in the civil fraud case determined that Trump and his company engaged in persistent fraud. That finding was not a criminal conviction for perjury, but it was a judicial determination that the financial documents at the heart of the case contained deliberately deceptive elements. When your CFO confesses to perjury for lying about these exact same documents, it changes the conversation entirely. The legal vulnerability becomes severe. Perjury is a significant offense in both state and federal courts. Unlike other white-collar crimes that might result in fines, perjury is treated seriously because it threatens the integrity of the judicial process itself. The thing about perjury that makes it so dangerous for Trump is its transparency. You can try to explain away complicated financial transactions with accounting jargon. You can argue about intent. But perjury cuts through all of that. You either told the truth under oath or you didn't. There is very little wiggle room when you are caught in an unambiguous lie. The institutional structure of deception that Weisselberg's plea reveals is critical for understanding the full picture. This wasn't a rogue employee deciding on his own to commit perjury. This was the CFO, one of the highest-ranking officers in the company, lying under oath specifically to defend Trump's exaggerated wealth narrative. This indicates that the deception wasn't an anomaly, but rather a feature of how the business operated. If the CFO felt comfortable committing perjury to magnify Trump's organizational perception, what does that say about the corporate atmosphere? What does it say about what Trump expected from his top people? Legal experts have communicated that if prosecutors decided to earnestly investigate perjury charges directed at Trump himself based on his sworn statements, they would have considerable material to work with. The depositions where he contradicted documents, the trial testimony where he made assertions that diverged from the proof, all of that is now part of the judicial record. The question centers on whether prosecutors decide to pursue this path and whether they believe they can prove beyond a reasonable doubt that Trump deliberately lied rather than simply being confused or engaging in his trademark hyperbole. The connection to Trump's other legal difficulties magnifies this substantially. He is already dealing with the fallout from the New York hush money trial. He faces persistent claims and potential exposure in multiple other jurisdictions. And now, his CFO has admitted to perjury. The walls keep closing in from every direction. And sitting at the foundation of everything is this question regarding whether anything Trump says under oath can be trusted. When you are a defendant whose personal CFO confesses he committed a crime by lying in court to protect the boss, you are handling something that surpasses typical legal risk. You are dealing with a foundational credibility crisis that taints everything. Let me bring everything together and explore what this means for Trump moving forward, because the perjury situation creates a distinct category of risk. With Weisselberg's plea, we now have confirmation that key players in Trump's inner circle committed crimes by telling lies under oath to maintain his financial image. That is no longer an allegation, it is a conviction. And it invites the obvious question that prosecutors will continue to ask. If the CFO lied under oath about Trump's finances, was Trump lying too? Trump's advocates will undoubtedly argue that any inconsistencies in his statements were innocent confusion rather than deliberate perjury. They will assert he genuinely believed what he said, or that valuation is an art, not a science. These are standard legal defenses, and prosecutors would have to overcome them to secure a conviction. However, the pattern remains significant. When you see the same types of misstatements repeatedly, consistently directed at portraying Trump as richer or more innocent than the evidence suggests, it becomes challenging to maintain that these were merely honest mistakes. The institutional structure of deception disclosed throughout these proceedings should produce concern for everyone, regardless of political orientation. The judicial system depends on truthful testimony to operate. When powerful figures face no accountability for false statements, it sends a message that the rules do not apply equally. Weisselberg going to prison for perjury matters because it shows accountability exists. However, the substantial question remains whether that accountability will ever extend toward Trump himself, or whether he will continue to escape consequences while the people surrounding him absorb the blow. The atmosphere of legal jeopardy isn't fading. In reality, it gets increasingly ominous as more evidence surfaces and more associates confess their wrongs. Thank you for watching. If you found this analysis valuable, Please subscribe for more in-depth coverage of these developing legal stories.